Hello and welcome to a quick roundup of Inside the Courtroom, the Senzo Meyiwa murder trial wrap. I'm Mnisi. Now, the trial returns to court on Monday after ending the year with a plot twist. Let's break it down. Before the year ended, the court was hearing from the witnesses of accused number one, Mnisi, who is one of the alleged lookout men. Now, on the stand was Sifiso Zungu, known by his clan name, Gwabini. This is one of the witnesses who was lifted from the state's witness list after he was not called to testify. What do I mean by this, you ask? Now, after presenting evidence and at the closure of their case, the state can make available to the defense witnesses it did not make use of, and this is what happened with Zungu. The state believes that he was the alleged host of the gathering at the hostel where the murder of Senzo Meyiwa was allegedly planned. The court previously heard from his uncle, Sizwe Zungu, who testified that his nephew invited him to the hostel that day. But when Zungu got to the stand testifying in the defense case, he denied this.
Now, he proceeded to tell this court that whilst in that very same room, he also took the .38 special revolver from Mnisi and looked at it.
It's telling lies.
He further told to this court that his observation of what was happening in that room was that those firearms that were in possession of accused number one and accused number three, now the .38 revolver and the 9mm pistol, were firearms that had to be handed to you.
You're telling lies.
Now, why do you say, of all the things that I've put to you that were said by Constable Zungu here at court, and then you say he was lying, why do you say Constable Zungu was lying?
My lord, the reason why I keep on saying that he is telling lies or he's lying, I just didn't know Zungu in 2014, just for the entire 2014. The last time I saw Zungu, he was still young. It was in 1998, if I'm just not mistaken, or if I'm just guessing. It was in 1998. And when I saw him again, it was in 2017 when he arrived with Makosonke, and it was a complete surprise to me when they arrived.
According to the state, it's in possession of a statement that was deposed by Zungu in terms of Section 204 of the Criminal Procedure Act. Now, a 204 witness is an accomplice who testifies for the state in exchange for indemnity, but on condition that he or she tells the truth. Zungu's testimony is to the effect that he was subjected to an arrest characterized by severe assault with a firearm planted under his bed in June 2020. He told the court that he was moved to the municipal offices.
They then started asking me, how did Senzo Meyiwa die?
When that happened, you were still in the vehicle.
By that time, we were at the municipal area,
yes,
but still inside the vehicle. I didn't alight it from the vehicle.
Okay, proceed.
The mistake that I made, or the wrong thing that I made, was for me to say that I know nothing about football. I know nothing about soccer players. They then instructed me to alight from the vehicle. Indeed, I alighted. When I alighted from the vehicle, I was instructed to sit down and seated in a position as well, in such a way that I stretch my legs. Yes. My legs are stretched out, yes, with my hands at the back.
Take us through how this assault happened. How did they assault you?
I was seated, and then my hands cuffed at the back, and I was facing that way, and then they appeared. The one that appeared from the back or from behind, I couldn't see that, or I didn't see that one. Yeah. Because they were seated in a buggy, a double cab, which was open. They were seated there at the back of it, and I was made to sit down. And then this particular one then covered my face with the plastic. That is, with the plastic that they had covered me.
He told the court that the assault moved to the cemetery and he was ultimately taken to Primrose Police Station the next morning. This is where the disputed statement was made.
From there, they then asked me, do you remember the South African goalkeeper? I then said to them, but I don't even watch football. They then said to me that it would be beneficial to you if there's something written down, because Mnisi said something, or something is written which was said by Mnisi about you. They then showed me a pile of documents.
Yes.
I then said to them, or gave them just one word, that whatever it is that was written by Mnisi about me, take it from wherever it is written and bring it over this side, because I know nothing. I've never ever been arrested. There's nothing that I know.
Yes.
They then wrote down, and then I just signed or wrote an S, because I told them that I know nothing. Whatever it is that was written or said by Mnisi about me, take it from where it is and bring it over this side. Maybe my brother just wrote something or said something about me, not knowing that I don't know anything. I just signed or wrote that S.
The state wanted to use this statement to cross-examine him, but the defense objected to this, saying that the state should first prove the statement. This prompted arguments on the legal provisions of this. But there was a dramatic plot twist before the arguments could be heard. A security threat on the judge, prosecutors and investigators. This after Zungu flagged that some of the people he had come to court with had been taken by police.
I can confirm that we have registered a case of conspiracy to commit murder. We have been investigating this particular case for quite some time. We did take 3 people in for questioning for further investigation and profiling. We can confirm that they have been released. So the reason why we took them in for questioning is that we received solid intelligence corroborated by gadgets and electronic devices that we have seized, that there are high-ranking officials that are being targeted in the Senzo Meyiwa trial. And evidence at our disposal is that these individuals attend court proceedings looking for the opportunity to take out, murder these individuals as they enter court or as they leave court. So the steps taken today to take in people for questioning was for us to be proactive. We cannot sit with information. If we notice or suspect that certain individuals fit the description of those that we are looking for, then we have a right as the police to take people in for questioning, profile them, and so on.
Now, in another revelation, the defense told the court that they were also being probed in this alleged assassination plot.
There's information that was conveyed to us when we went to go and find out yesterday, subsequent to the request that was made to see the 2 gentlemen that are accompanying our witness here. There's a person who identified himself as an investigator in these threats or in these new developments which amount to security threats. He identified himself, and then he said, and I'm going to repeat it on record, that they were targeting, that they were after certain individuals who were seated here at court, and they've been monitoring them for some time. But yesterday, when they were about to approach them, they were no longer able to see them, and that those individuals had disappeared. So they are suspecting that we are the cause of their disappearance.
The dust eventually settled after security was heightened in court. This paved the way for arguments to continue.
We submit, my lord, that at this point, the only question is what to make of his explanation. We submit that the point is that his explanation must be tested as to reliability through cross-examination. We submit that it's a credibility issue, my lord, as to whether his statement is trustworthy, and therefore that the statement itself needs to be examined through cross-examination.
The defense argued that the state, in its arguments, did not address the crux of the issue.
I thought that the state would come up with something totally, something that is totally out of the realm of the ordinary, from the process that is known with regard to how a statement of a witness is being dealt with if the credibility of that witness is to be challenged, my lord. At the moment, I thought that the state would come up with an authority that says, no, there is an exception to the fact that before a witness is impeached on your statement, we don't have to prove your statement. I've gone through their heads of argument. There is nothing such as that, my lord. All that the state is talking about, they are repeating the evidence of Brigadier Keninda, which is already on record. They are repeating the evidence of Mr. Zungu, which is already on record. They are talking about the interest of justice that we all know. They are also talking about the evidence of Mr. Kwabeni that is already on record, and a whole lot of areas. But one point that the case is, that the state is missing is to come up with exceptional circumstances where a witness can be cross-examined on the basis of his statement without proving that statement.
For the first time this year, the court will sit and expected to hear from witnesses who were allegedly involved in the assault of Zungu. The first witness possibly being the lead investigator, Brigadier Bongani Keninda. Those proceedings expected to start on Monday at exactly 10 o'clock. For Newzroom Afrika on Channel 405, I'm Mnisi.